AI bubble is inflating. Recent headlines about a hyped AI startup tell us that tools are raising millions. But inside firms, adoption is razor thin. When the bubble bursts, you'll either be holding contracts that nobody uses or running systems that create leverage. In this video, I'll show you 6 rules to filter hype from reality and 6 practical steps to make sure your firm is on the right side when the crash comes. I'm Rok, founder of MPL Legal Tech Advisors. With an engineering background of building compliant AI systems in finance, we now consult law firms and legal teams on AI strategy and adoption by putting governance and people first. Let's jump straight into the problem. Enaguo's independent legal AI benchmark found that the tool with the most funding ranked lowest on usefulness. And in firm discussions online, the same story keeps popping up. Shallow adoption, shaky renewals, tools used by juniors but abandoned by partners. One firm even signed a 6-figure deal only to admit at the renewal that nobody was logging in. And that's when you confuse funding and media pump with adoption. Now this is the real problem. In the sea of demos, partnerships, and hype-driven announcements, firms are left guessing. Who do you trust? What do you actually buy? And how do you make sure that the people actually use it once the contract is signed? So there are 6 rules that every firm should follow. Rule number 1, measure behavior and not the headlines. Don't confuse funding with adoption. We worked with a firm that signed a big AI contract. It looked great on paper, but when we checked the usage, only a handful of associates even logged in. The partners tried it once, didn't like the output, and never came back. The adoption is not about the contract size, but it's about who is using the tool and if they're using it day to day. If you want to know exactly where your adoption is breaking down, book a free consultation call. You'll find the link in the description below. Rule number 2, make sure you're solving the real bottleneck. If your AI isn't fixing something that's actually painful, like intake, document review, client emails, it won't stick. I see too many firms buying flashy features that don't actually touch their real headaches. Just focus on the top 5 bottlenecks or don't even bother with the tool. You're just wasting your time. Rule number 3 is don't buy without a workflow plan. Multiple firms we've worked with bought a tool after an impressive demo, but when we mapped their actual workflows, there was no fit for the tool. Now, if you can't point to the exact step where the tool is going to be used, such as automating retainer generation, it will just sit unused. And I couldn't make a better point myself. As one of the founders of Saga Legal posted this week, if you buy an AI tool without a plan for the adoption, you've already lost. A much needed sanity check from Remco. Thank you for that. Rule number 4, measure adoption by who is using it. Check the usage logs. Are partners and senior attorneys actually using the tool, or is it just the juniors? If the output isn't trusted in the real client work, you haven't achieved adoption. You just spent money. Rule number 5, don't assume partnership equals usage. A press release about your new AI partner doesn't change how the documents get drafted. We're seeing that all over. Firms are celebrating big AI vendor partnerships, but if you look behind the curtain, day to day, absolutely nothing changes. And rule number 6, put governance in place from day one. Without clear guardrails, AI is a liability. Set simple red, amber, green rules. What's safe, what's risky, and what's completely off the table. This gives your team confidence and actually drives adoption. Alright, so we've been through the rules now, but what do you actually do on Monday morning? Here's the checklist that we use with every firm. Step number 1, run a structured evaluation. Don't just trust the vendor's demo. Test the tool on your own matters, on your own documents, and on your own workflows. Measure the real time saved, measure how many errors have been generated, and check the compliance before you buy. Step number 2 is start with a defensible pilot. Define the scope, define the success metrics, and define the risks upfront. At the end of that pilot, you want a scorecard that you can show to your partners, not just vendor promises. Step number 3 is map your workflows first. You'd be surprised how many inefficiencies you will spot yourself once you do that. And who knows the process better than you? Before you buy anything, figure out where does the tool fit. Does it fit the intake, drafting, review, or does it force you to do those things completely differently? And if you can't name one step where you need a tool, you're not ready for it. Step number 4 is put your guardrails in place. As mentioned, clear rules for what's safe, risky, off limits. Now pair these with clear verification steps so your work will stand up to scrutiny. Step number 5 is check compliance. Stress test the confidentiality, data handling, data retention, and all the regulatory requirements before you adopt. Fixing compliance after the fact is way more expensive. And step number 6, pair adoption with governance. Policies alone won't change any behavior. You need training, usage monitoring, and feedback loops, so the adoption grows and stays defensible. All the frameworks that I mentioned throughout the steps, evaluation scorecard, defensible pilot, compliance checklist, guardrails guide, they're all linked below for free. Download whichever you need. And if you need a partner to take you through this is exactly what we do at the MPL Legal Tech Advisors. We consult legal teams and law firms to go from A to B much faster, because we've been through it so many times. Book a free consultation call with us. You'll find the link in the description. Thanks for watching. Subscribe for more practical frameworks every week, and I'll see you in the next video.